FORA.tv. The world is thinking.
What does the history of the creation and the ratification of the Constitution have to teach us about the current issue of same-sex marriage and whether there should be a constitutional amendment on that point?
After you, Walter.
Well, there's a lot to be said on the issue of same-sex marriage, but I'm not sure that there's anything in the founding generation that would address it. I'm thinking hard and fast here. I suppose that as someone who supports that notion, if I were to try to come up with an argument to gain support from the founding generation, it would be that we are a nation built upon constitutional change and evolution, and that unlike countries that have very fixed systems, what is essential about American identity is that we're always and ever evolving. But that would be the best I could come up with, and I don't think that's actually particularly good.
Thank you.
Well, and I think it's fair to say that the original Constitution probably doesn't speak very directly to this. I mean, you know, there obviously part of the debate, for example, is, okay, there is an amendment process in the Constitution. So what does that tell us? I mean, how much, when it comes to recognizing new constitutional rights, do we want to do that through the process of amending the Constitution, through the amendment process itself? And how much do we want to have essentially judges interpreting relatively broad provisions in the Constitution in a way that may sort of sap the need or the will for the amendment? Because if you have an interpretation of the Due Process Clause that everybody thinks is pretty hunky-dory, well then why would you ever amend the Constitution? Because it kind of evolves through various interpretations of the document. So that's one area where you might be able to trace the issue. Then the other, I think, interesting issue that lurks under the surface of the same-sex marriage issue is, and I think it comes to right what Walter was saying in response to the Chisholm against Georgia question, which is, what was the residual role for the states? How much, what did the federal government take over? How much was the federal government a general government? How much was left for the states? I think there would have been a sense that at the time of the framing, to the extent the question of marriage came up in government, it would be in the state houses and not in the United States Congress. That was not one of the, certainly not one of the issues that led to the founding of the federal government. So, you know, I do think that's another issue that kind of lurks below the surface.
And that leads me, by way of friendly rejoinder, to talk about the fact that the 14th Amendment wasn't simply a revision or an alteration or an amendment. The 14th Amendment fundamentally changed America. Before the 14th Amendment was adopted, and before the Civil War, the notion that the federal government would guarantee rights of citizens in each state against their own state government was both a ludicrous idea in theory and even more ludicrous in practice. Every state government, most state governments had a bigger budget than the national government before the Civil War. The Attorney General on the eve of the Civil War was a part-time officer who had 2 clerks and a messenger. After the Civil War, you built the Executive Office Building, which was unthinkable before the Civil War. It was the Civil War was not just the largest project of the national government to that date, it was larger than every project of the national government from the beginning to the Civil War combined. And in its aftermath, they passed a constitutional amendment saying no state shall not do some certain specific things, but denied any person privileges and immunities of citizenship, deprive persons of life, liberty, or property without due process, deprive to any person within his jurisdiction equal protection of the laws. And they proposed it and gave Congress the authority to enforce this. This was a very revolutionary change. And done against the backdrop that between 1787 and 1868 and 1870, the courts had given very expansive interpretations to the power of judicial review. See Dred Scott. see not just
Never a
Chisholm
great
against
example.
George, never a great example. But Fletcher against Peck, the federal courts had asserted great authority to interpret provisions of the Constitution. So the 14th Amendment was passed by Congress that knew what it was doing and ratified by the states, and that fundamentally altered the fact, and it made the federal government, for better or worse, gave it authority over the rights of citizens against their own state governments. And whether any particular application of that right is a correct one or an incorrect one is, of course, another question. But the legitimacy of the inquiry, and Randy Barnett is nodding, the legitimacy of the inquiry is no longer in doubt after the adoption of the 14th Amendment.